have no discovery. We talked about that last time, and I told you last time that I wasn't gonna give you an answer on that until I got my discovery, which I still haven't got. I put in motions about the discovery, but I guess you wanna wait till after you try and railroad me and push a lawyer and speak for me. I want my discovery. I want that 6 months set, and yeah, and I want those motions to be, because there's no reason that I should be here in this courtroom being railroaded by you guys. Let the record show that the judge never looked at me or acknowledged anything that I said.
Rose, I'm gonna send something for printing.
I'm not signing anything you give me. Yeah, I don't agree to anything that you say or anything out of this corrupt court.
Okay.
So, go ahead and save your ink and your paper, because I don't want it. I'm not signing it, if that's what you want. And if you think you're gonna force something on me, you gotta understand, Judge, I'm innocent, right? It shouldn't even be
Alright.
going to trial, this is
What
straight
I've done
railroad.
is, what I've done is printed out a waiver of attorney form. It's been filled out already. If you don't want an attorney, you can sign the form and then we'll move on.
I'm not signing anything, I told you.
Do you want an attorney or not?
I'd like to know what's going on with these
Let me
motions.
rephrase that. You've already indicated to me you don't want an attorney, so for the
No.
record, I'm gonna indicate.
No, I told you I don't want you speaking for me, that I never said that. See, there you go speaking for me again. I need a new judge. You're a bad judge.
Okay,
You're speaking for me. Stop speaking for me, because what you have to say and what I have to say are completely different things.
I'll tell you what we'll do. Why don't you
recuse yourself?
go ahead and address your motions? They've already been ruled on, but go ahead, start in order that I presented them to you.
Presented what?
You saw the minute entry.
You haven't given me anything.
There was a minute entry entered on your motions.
I haven't got anything.
It was mailed to you, it was issued on, let's take a look. March 20th, 2025.
And I haven't got it.
Alright, can you print him a copy of your minute entry?
Thank you.
All of those.
And what did you rule on those?
Well, you can read it for yourself. In the meantime, while we're waiting that for me printed out so you can read what I've already done,
I'd rather you tell me instead of making me have to guess, right?
you're not gonna guess, you're gonna read it for yourself.
No,
Meantime,
I want you to explain that though.
well, you have.
Because I already know that you're trying to railroad me. You're not trying to let me out of this court.
Alright,
You know?
so, and the end result is today, do you want me to set a trial date or not?
I've wanted you to do that from day one. Is it going back all the way from day one? Is it going back from day one?
Is what coming back? I'm gonna set the date for you here today.
The 6 month, I want my right to, I've been asking for that since the first day I came here.
How about May 16th?
How about we do it,
9:30
how about we
a.m.
do it from the day that I came in?
May 16th is your trial date, how's that? That's,
The state does not have a conflict with May 16th.
alright, we will set the trial date for May 16th.
Let the record show that the judge is setting the trial date and I haven't even got disclosure or discovery or anything.
Well, we established at the first hearing that you did receive electronic disclosure.
Well,
What we're waiting for
what
is
is-
the written disclosure, so.
Sorry, if the state didn't make a record, Your Honor,
Sure.
Bagger, the assigned prosecutor on the case, emailed Mr. Gonzalez on March 3rd and April 9th with information on how to obtain electronic disclosure from our office.
I'm not asking for electronic disclosure.
Please don't interrupt her.
Who's asking for electronic, have I asked you for
Please
electronic
don't
disclosure?
interrupt her. Go ahead.
We have no record of him attempting to download or obtain disclosure electronically via Justice Web, which is the system that we use. We also have no record of him contacting our office for assistance with obtaining the disclosure. The state is prepared to set for trial, but if the defendant does not obtain his disclosure, we still intend to go through with the trial.
Well, I want my disclosure, and that's the simple fact right there, is because you guys are tracking to see if I'm doing it or not. I can't do it, and I haven't been able to do it, and that's what I've been saying. And I want my paper copies, plain and simple.
What
Let
we
the record
acknowledge,
show that I'm asking for my discovery, and I've been asking for my discovery, and your guys' little record thing that you guys do is garbage and stuff like that. I want paper copies of I want paper copies, plain and simple.
And you don't have to say for the record, everything we say is on the record. At the last hearing, you acknowledged that you had the link for the materials.
But I haven't been able to get into it, and I don't have service, so let's put it that way. I put in a motion for copies, man. And I told you that I wanted copies in, and you guys try to push this on me like you keep trying to push it.
Do you have a copy of my ruling now?
Motion to.
Provide him with a copy?
Yes, I did.
Alright, why don't you turn to page 2, look at number 6, and Ms. Theobald, did you see the minute entry I entered on March 20th?
Apologies, Your Honor, let me go through the file. I'm suffering from Mr. Badger today.
Yeah, well, I understand that. If you take a look at it, you'll see that what I did was,
I don't see it on here.
in defendant's motion number 6, which is paper discovery, I wrote, the prosecuting attorney sent disclosure to defendant via email, the most common method of delivery. Because there has been no objection to defendant's request, the court grants defendant's motion for paper copies and orders the prosecuting attorney to provide the defendant with paper discovery and any videos or photographs on DVDs either by U.S. mail or by hand delivery. Obviously, they're not here today, so we will work on that problem. Yeah, see that we have. So I've already granted your motion for the paper, and you will get that material, so we will make sure that you get them.
Well, I think I need adequate time, don't you, Judge, instead of just trying to reel me into a.
I'm trying to provide you with
You're
the
not-
speedy trial that you wanted, so.
You're
if
trying to
that
do
comes-
everything you can to mess me over. Right?
If May 16th doesn't work.
No, how do I have enough time to do that? Do I get enough time to interview witnesses, or I don't get that opportunity here?
You
It is.
can have-
That's
How
the
much-
right. That right don't.
How much time do you want before trial?
The 6 months. I want before my 6 months. I want to be able to get my discovery. I want my interviews. I want all that stuff. I mean, I don't know what you're thinking. We're just gonna just fast track this or what?
Well, you wanted a speedy trial.
I want a speedy trial, but I want a fair and unbiased trial, Judge, which I'm not getting in this courtroom, which has been pointed out.
How much time do you need, do you believe?
I want a different judge. I want a different court. I want everything else besides you sitting in front of me.
Okay, now, going to my question, how much time do you need to set the trial?
I have a right to a speedy trial. How long do you think I could get to get my interviews and my witnesses?
How about if I set it in July, is that enough time?
How do I go about getting my interviews with my witnesses?
You want an attorney? You can ask your attorney that, I can't. give you
But I
that.
thought you were my attorney. Well, you're speaking for me.
Okay.
You
So
can't
you
answer
want an
questions.
attorney or no, you don't?
I want a different judge. I think you're the worst judge I've ever been in front of.
Alright.
I want a change of venue. There's conflict of interest here, Judge, and you know it, and you're still trying to keep me here to railroad me into this charges. Show me the crime. There's not even a crime that I committed. I don't even know what you guys are trying to get me with because I don't have discovery.
Well, I didn't charge you with a crime. So if July is not enough time for you, how about August?
How about, let me think. I want my discovery and I want to interview my witnesses. How about that?
I'm gonna set the trial date for August 7th at 1:30 p.m. And if that time does not work for you.
Is that for May? Is that from a couple months ago whenever I came in here?
August.
When did I come in here? When was my first day that I seen you and you insulted me?
Back with us?
Yes, apologies, Your Honor. I just got the minute entry right now. That was not in my file. I do
Okay.
apologize. We will get the paper discovery.
And who am I talking to? I don't even know who I'm talking to.
Please stop interrupting her so
Why
we can
can't,
talk.
it's around the corner. You guys are connected parking lots. Why can't she be in here?
Okay, that's not your decision to make. So what we're gonna
Do I have
do
to come to court?
is, you could have attended by Zoom. You wanna attend the next one by Zoom, you're more than welcome to.
No, what I'm saying is I wanna know who's confronting me. I have a right to see who's talking smack, right?
Laura Theobald, now, back to what you're saying, that's fine. When do you think you can have that, sent by US mail? Just ballpark.
I will get it in by the mail by tomorrow. I'm currently emailing the staff in charge of that.
Okay,
And
excellent.
notify your witnesses that I will be wanting that to speak with them. My what is it called, Judge? What do you call it? When you talk to when you talk-
Interview?
yeah, I want to interview these guys. Make sure you let them know that
Alright, well, you make those requests in writing to the prosecutor.
Well, I just wanna put it
You'll
on the
have,
record.
it's on the record, everything we say is on the record.
Yeah, exactly, that's why I said it.
So, what we're gonna do here is because you should have assuming it goes out in US mail by the end of the week, you should have it by the end of next week. That puts us at April 19th, I would say 18th at the latest. You need time to interview witnesses. I would think that by July you should be done with that, so I'm offering you let's just set the hearing date instead of August. We'll move it faster, cause you want speedy, so let's get it.
Well, I wanna talk about these motions first. How come you refuse to remove yourself from my
I've
case?
already asked you to state your case on those.
Well, did you? Well, I'm telling you right now, how come you're refusing to take yourself off my case?
There's a minute entry.
I can't read, I don't have glasses.
You want me to read it to you?
Yes.
Alright, are you gonna let me do that without interrupting me?
Yeah, that's the only way I'm gonna be able to hear it, right?
Alright, let's go through the minute entry. This is the minute entry dated March 20th, 2025. Defendant's motion number 1, which is the request to audio and video broadcast. The court grants the defendant's request. The device used must be a handheld device and used without any other devices such as a unipod or tripod. Further, this permission can be withdrawn at the court's discretion if the court finds it is interfering or disruptive with court activities. Do you have any questions about that ruling?
No, I wanna know why you're not removing yourself from my case.
Defendant's motion number 2.
Do you think that you can give me a fair and unbiased trial?
Defendant's motion number 2.
I think record shows not.
Change of venue. Arizona Rule of Criminal Procedure 10.3 governs a change of venue. At the hearing, the defendant requested a change of venue and the court instructed defendant to file a motion pursuant to Rule 10.3C and provided defendant with a copy of the rule. Defendant's motion fails to state any facts to support the general assertion that he cannot obtain a, quote, fair and unbiased trial due to Judge Roberts' practicing law from the bench and Judge Roberts' ignoring the fact that I'm in the Ninth Circuit Court with superior justice in state courts.
Well, that, Your Honor, I was sick.
Finally,
So.
the defendant asserts that he has been talked down to and insulted by the courts and not given due process, referencing Judge Roberts. Judge Roberts is no longer on the bench, having retired as Precinct 10's JP. Further, the current JP has not heard any prior cases from the defendant, and the defendant has not set forth any specific facts that this court cannot provide a fair and unbiased trial. Because there are no facts to support this motion, the court denies your motion.
And I redid that, and I sent those in. Why didn't
I
you
have
talk
not
about the
received-
motions with your name on it, Judge?
I have not seen those yet. Defendant's motion 3 and 4, remove
Of
judge.
course you haven't. Crooked
Change
judge.
of judge is governed by Arizona Criminal Rules of Procedure 10.1 and 10.2. Defendant's request for a change of judge as a matter of right is untimely and is therefore denied. Rule 10.C1A is that rule. Defendant's request for a change of judge for cause must show that this court's interest or prejudice would prevent a fair and impartial hearing or trial. That's Rule 10.1A. Defendant, however, failed to support the request with specific grounds that are supported by an affidavit, as set forth in Rule 10.1B1. Defendant's 2 motions reference vague allegations without any supporting examples or references to the record, and reference those.
Let the record
allegations
show that the judge's
proper.
smug remarks and
because-
sassy remarks on this.
And because-
He's so happy about screwing me over. You're a bad judge.
And because this court denied defendant's request to change venue at the last hearing, the allegations to Judge Roberts are no longer relevant as he is not on the bench. Further, this court did not deny defendant's request to change venue. Rather, the court instructed defendant to file a motion as the rule requires and provided defendant with a copy of the rule as set forth above.
And what
These
happened to that?
reasons-
And what happened to that motion that I sent you?
Defendant's request for a change of judge for cause is denied. Defendant's motion 5, speedy trial. Defendant did request a speedy trial at the hearing. However, the court has not failed to provide a speedy trial. The right to the speedy trial is governed by Arizona Criminal Procedure Rule 8 and requires a trial within 180 days. That's Rule 8.2.
Yeah, from the day that I asked for it, not when you want.
Given that this case is not close to that time limitation, the court has not denied defendant a speedy trial. Assuming all parties are prepared for a trial, the trial date will be set at the hearing scheduled on April 10, 2025 at 1:30 p.m. That's today's hearing, and I am ready to set the trial to give you the speedy trial. So,
I was asking for you, I was asking for this for day one, for you to give me a speedy trial.
and I
Then-
saw you on March, that's 180 days we got to go. So, let's set it for July 18th at 1:30, bench trial.
I want a new judge. It's obvious that I can't get a fair and unbiased trial with you.
Would
I
you-
put in the motions, and I don't care what you say, I don't want you as a judge. You're the worst judge I've ever seen in my life, and I don't expect to get a fair anything with you.
Alright.
From the way you talk to me from the first day until all the way that you're trying to just railroad me.
And so what you're free to do, of course, is file an appeal against the rulings I've already issued, and you may do so.
I just want to see a different judge.
I understand.
Why do you refuse to take yourself off my court case when that you know I won't get a fair trial?
My explanations are in my order, and if you want to appeal it, you so can. We have sent a bench trial, alright. Let's go through this just really quickly. Pursuant to Rule 9.1, if you fail to appear for a hearing.
I think
Three
that you
things.
should hold off on doing everything you're doing until I get everything that I asked for, so that way, if I can see, because what are you trying to get me for?
Rule 9.1, I'm the judge, I'm not prosecuting you for anything.
Oh,
Requires that you
Yeah,
be
I know
here
you're
present at every hearing. The failure to show up at a hearing can result in three things. One, an arrest warrant can be issued. Two, you can be charged with an additional crime. Or three, if you fail to appear for a hearing, which includes the trial, if you fail to appear for the trial and the trial is held in your absence and you are convicted and not sentenced
Can
within
I go
90
now?
days,
Can I go now? I don't care what you have to say. Everything you have to say is bullshit. I don't care about anything you have to say, Judge. Everything that you say is it doesn't matter to me because I know you will not give me a fair and unbiased trial here. I can see it already. It's already been proven. Just let me go. If for some reason you want to keep me here and railroad me,
No, I'm gonna
right?
leave you
You guys
to-
are claiming to be the victims in a lot of these cases. and
one
then-
more thing,
What?
and then you're free to go. Pursuant to.
All right, can I go now?
That
I don't
any
care what you
defense-
have to say, Judge.
Any defense.
I don't care what
witnesses-
you have to say. I want you to remove yourself from my case.
You have.
You understand
the
that?
state-
You're an unfair and unbiased trial, and there's no way that I could ever get a fair. I can't even believe you're a judge. How about that?
Okay.
I don't want you as a, who do I talk to get you taken off? Since what, I could just put in more motions now, or what?
You should go up to Superior Court and appeal the ruling I've already made. So, I've advised you pursuant to Arizona Rule of Criminal Procedure, Rule 15, that any defense witnesses along with.
Are you done? Are you
Any
done?
defense exhibits must be disclosed to the state no later than 20 days before trial, or they may not be called as witnesses, or the.
I notice you like to stick to the sticklers on me, huh? But what, like, you know I don't have a lawyer and you're trying to come after me. I told you I want my motion. I want my discovery, because I don't even know what you guys are trying to get me with. I want my discovery. I want my interviews with the witnesses.
All right.
Other than that, I don't give a shit what you have to say. You can keep all your stupid ass opinions to yourself, and you're the wrong judge for this.
So I have issued the minute entry and advised you, all the advisories I read to you are contained in the minute entry so that you will have notice for that. And we are concluded, and with that, we are off the record. Thank you, Ms. Steeple, for attending.
Take yourself off my case, Judge. You're the worst judge I've ever met in my life, and it's obvious I can't get a fair and unbiased trial with you. Do you get that?
We
You
are
don't
finished
care.
here.
You just want to keep me
And
here
we are
so you
off
can
the
fuck
record.
me. I'm not down with that shit. I'm not down with that.
Thank you,
Can I
Your
throw
Honor.
this away somewhere?
You bet, you're excused, go ahead.
You're a crooked judge. I don't want you as a judge. It's obvious by the
If
way
you're
that
not
you
going to
talk.
leave the courtroom, I'll have security.
I'm looking for a garbage. What do you want me to throw right here? Where do you want me to put it?
Right there in the garbage can.
All right.
All set?
Just throw it right on your bench.
You don't want to threaten me.
I'm not threatening you. I said I want to throw it where the trash is at. The garbage.
Gotcha.
That's what I mean.
All right.
Take yourself off my case. There's no way. I can't believe this. Take yourself off my case. This is a conflict of interest.
Let's have security come on.
Fuck security.
Let's have him come on.
Yeah, tell security they can suck my dick.
Incidentally, the authority or the right to videotape and broadcast this is limited to this courtroom, Mr. Brown, so you're aware of that fact. Okay?
Yeah, well, it's limited to the courthouse too, but this courtroom,
I
yeah.
gave you permission for this courtroom only.
Don't
Yeah,
acknowledge him.
yeah, you have no authority out here in the courthouse.
All right.
In the courthouse, I can do that.
Letting you know.
I'm letting you know, you don't have an authority out here.
I enjoyed myself.
I mean, I wish I was a little bit
Hey, hold on.
smarter.
Hold on, guys. Hey, hold on.